Thank you, Mr. Chair. Attorney General, on May 15, 2024, you sent a letter to President Biden recommending he invoke executive privilege on audio recordings of his interview with Special Counsel Robert Hur. In this letter, you claim the precise concern is that executive privilege protects materials related to a closed criminal investigation where disclosure might hamper prosecutorial efforts in future cases. Is that correct? I think you stated that earlier.
Yes.
In this letter, you also wrote that you are concerned about the prospect of committees of Congress obtaining confidential records from Justice Department of criminal investigative files for the purpose of addressing highly politicized issues in public committee hearings. Is that correct as well?
Are you citing my letter?
Yeah, in the letter
that's correct. Yeah.
Right. So let me go back. In the United States versus Mitchell, during the Watergate District Court case, Judge Sirica held that by releasing portions of a subpoenaed recording in transcript form for publication, the president's claim of confidentiality and that privilege associated with it was no longer valid since the conversations were no longer confidential. You produced the transcripts to this committee, correct?
Yes.
And prior to producing the transcripts to the committee, they were leaked to the press. So based on Mitchell, which is still good law, the recordings are, in fact, no longer confidential, aren't they?
Can I respond? I'm sorry, that's not what Mitchell was about at all. Mitchell was, first of all, about transcripts created by President Nixon, for which there was plenty of reason to believe that they were not accurate. And secondly, it had to do with the confidentiality of communications between Nixon and his staff. And once he provided the transcripts, the court said those communications were no longer confidential. That is not the allegation. That is not what we're asserting here. Here we're asserting confidentiality over the audio, not confidentiality, but protection of the audio in a criminal investigation, an interview, not a staff meeting.
Okay, thank you. Let me move on. Your May 15th letter also relies on the argument that producing the audio tapes would affect the department's ability to obtain vital cooperation in high-profile criminal investigations, in particular, in investigations where the voluntary cooperation of White House officials is exceedingly important. Is it your testimony that a White House official would voluntarily cooperate in a criminal investigation only if the Justice Department promises not to release the audio recordings? It doesn't make any sense.
The long-time experience of the Justice Department is also reflected in the declaration that was filed under oath, is that witnesses want to protect the confidentiality of their communications with the prosecutors during these sensitive interviews. In the Cheney case, the Justice Department made the same claim, even with respect to FBI notes about interviews of Mr. Cheney and that special counsel. It's our view that we need witnesses to be willing to be tape recorded or audio recorded, and that they are going to be less willing to do that if they know it's going to be made public. In the declaration that was filed in court on Friday, the senior official stated that he knew of cases right now where people are unwilling to provide audio because they are worried about it becoming public. So the answer is yes, that is our view.
Attorney General, have you listened to the audio recording?
I have not, because there's no reason for me to listen to it in order to make the determinations that I had to make. We had the special counsel describe in detail his explanations for his determinations.
So let me, I don't understand how you can kind of sit before the congressional committee and kind of arbitrate what's indistinguishable from the transcripts if you're not even sure what's on the tapes themselves.
I'm not doing it on my own. I have.
So you're saying other people have listened to it within the department?
Within the department, and the special counsel has listened to it, and the special counsel had every interest in ensuring that the transcript that he produced in order to do his investigation would be accurate. Yes, that's right.
Okay, so let's go back. So in May 15th letter, you also